just wonder if we're getting into an area where the court is going to be making some decisions on that we probably shouldn't be asking questions.
We're going to, thank you, Senator. We're going to move on. Thank you, Mr. Black, for being here today. I just have a couple of questions for the Attorney General, if I may.
Good morning. I think it's still morning. Okay.
I'm trying to get you back to work.
Yeah, I appreciate it. Thank you very much.
I would just, before I ask the question, state your name.
My name is Alan Gilbert. I'm a member of the Minnesota Attorney General's Office, and I'm the State Solicitor General.
Well, thank you for your patience, Mr. Gilbert, in being here today. I put together some questions, and I do not believe, and I mentioned the reason that we started late today is because we have client attorney privileges. I understand that that was not waived, and we're very restrictive in some of your answers. But I think I have some questions that have been asked of me by citizens that I believe we can go down that path. They're pretty simple. One, Minnesota Statute 8.06 reads, "The Attorney General shall act as the attorney for all state officers in all matters pertaining to their official duties." And the question that I'm being asked is, are we, or why is not the Attorney General's office representing the Secretary of State in the cases?
Mr. Chairman, if I might respond. First of all, just to clarify what you indicated about attorney-client privilege and attorney obligations, what we've been talking about, as you well know, and Senator Newman's been very helpful as well, is that there's an obligation on the part of attorneys under Rule 4.2 of the Rules of Professional Responsibility not to discuss an ongoing litigated matter with parties to litigation. As it turns out, I found out at 4 o'clock yesterday, Senator Parry, that you are a party to some litigation that was brought yesterday, as was Senator Ortman, and that would seem to be even a surprise to you this morning. So it's certainly new off the press. I then asked, and I thought it would be a simple request, that the attorney representing you and Senator Ortman consent under this Rule 4.2, because that's what needs to be done, to my discussing the merits of that case and related cases with you. And Senator Newman's been very helpful in trying to facilitate conversation with your counsel, and your counsel has finally decided not to consent because of the pendency of the litigation and the court hearing that's coming up on July 31. So I am not really able to get into anything as far as I'm concerned, even things that are intertwined, and I think everything is intertwined when it comes to the kinds of questions that you're asking today. So with all due respect, and based on Rule 4.2 and attorney-client privilege issues, I would prefer not to respond to any questions today in light of what your counsel has indicated.
I appreciate that explanation, and so we'll honor that.
I appreciate that.
Thank you very much, Mr. Gilbert.
Thank you very much. Mr. Chairman, Your Honor, I feel like I'm in court already. Although you're the honorable senator, certainly, but I do have copies of the briefs that have been filed by the Attorney General's office on behalf of the Secretary of State with respect to the title issue in the same-sex marriage case, so to speak. I'm happy to leave that with you if you would like. I can't make any comment on it in light of what we've already talked about, but if you'd like, I can certainly leave you copies so at least you can see what the legal position is. I noticed that you were asking some questions of Mr. Black, and the brief does respond to many of those questions.
That would be appreciated, sir.
Let me do that. Who should I leave them with?
Would you hand them to Lucas back in the
Okay. I will. Thank you very much. Appreciate it.
Thank you very much.
Okay.
Any further questions, unless there's any other testimony that anyone in the audience that we're not aware of would have? Any other questions, final comments? Senator Torres-Ray.
Thank you, Mr. Chairman. I have to say that I must, although I appreciate the attempt to really bring to the committee members' attention, about the calls that we receive from constituents and individuals who are concerned about the decisions we make. I feel that this hearing started with very strong accusations based on those calls that, Mr. Chairman, you have received. I was hoping that during this hearing, we would have had the opportunity to hear from those individuals who do not have strong party affiliation about how the Secretary of State has conducted his business and how that had been really interpreted as really campaigning. I would have hoped to hear from people at the county level who are being trained on how to implement the decisions that we make here, and that did not happen today. And just for public information, I want to make sure the public know that this hearing does cost money, so taxpayers will be paying per diem to the people who are around the table, as well as paying for our expenses and travel expenses. So there is a cost to the work that we do here today.
Senator Thompson.
Thank you, Mr. Chairman. I hope what's clear to the public as we went through the constitutional provisions that are at issue, the statutory provisions that are at issue, is there are very few things where the legislature can act without a signature from the governor. Constitutional amendments is one area in which the Constitution allows us to do that. And when you've got a case out there, the Stearns case, that says that part of the constitutional directive to the legislature is to direct the manner in which the ballot measure is presented to the people, there is no, in my view, legal reason, obviously, for the Secretary of State to change this. And I would submit that there is only one reason to not accept the title from the legislature, and that is that the Secretary of State, who has made his position on this issue very clear, nobody can deny that the Secretary of State opposes this photo ID amendment, is changing the title in a way to help his side of the issue succeed. We in Minnesota have a right to expect better. Yes, there are partisan elections for constitutional officers, Secretary of State, Attorney General, etc. But once those people are placed in their roles, whether Democrat or Republican, they have a duty to serve all the citizens of the state of Minnesota, and to use Secretary Ritchie's own words in his letter to Chief Justice Gilday, perform the ministerial function. Our Secretary of State has crossed the line in this particular instance and is being partisan. And that is something that Minnesotans should not be happy about.
Senator Goodwin.
Thank you, Mr. Chair. First of all, in my opinion, this constitutional amendment is partisan. To begin with, but the Stearns County case was not asking whether or not their title was formed by the Secretary of State, because had that been the question, should be provided by the Secretary of State, because had that been the question, the answer surely would have been yes, because of current statute 204D.15 that requires, not asks or says maybe he should, or he could do it. It says he shall do it. So I really think if that was the question in that court case, which obviously it wasn't, then it would have been a different decision. So I think we need to be fair about this, and the Secretary of State went through the process that says right here in statute. He made his decision on the title, sent it to the Attorney General. Attorney General approved it, sent it back, and the law was followed to the T. So I really believe that this is an issue over nothing.
All right. With that, I would just like to end with a final comment. I am deeply disappointed that Secretary Ritchie and Attorney General Laurie Swanson did not fulfill what I believe is their obligation to sit before the citizens of this state and answer questions. I am disappointed. I've always believed that they are better people than what they showed us today. My next action, whether it is to move forward and continue this investigation and look, will be made soon. And that could include different avenues. I will still take written testimony if somebody would like to submit, and will be in the minutes. As to the accusations, I believe there are still folks willing to come forward. I believe this committee hearing will open the door to that. I believe we will hear more from election judges and those who have sat in front of the Secretary of State and his staff. I believe now they understand that there is a belief that he is overstepping his bounds. I'm concerned that the Attorney General is not representing the Secretary of State, which I believe is also extra cost to the citizens of the state. And this is a serious matter. And we need to continue to address it and follow it, and with open transparency, which I believe this committee has done today. I'm still not sure that our Secretary of State didn't violate 211B06 based on some of the comments I've heard from the election officials and statements that our Secretary of State and his staff have made at their meetings, that they might not, that they could in fact fall underneath that statute. That will be a decision that this chair will also make in the coming days. So with that, ma'am, did you have something that you wanted to say?
Can I ask one question?
You would have to come up to the microphone, ma'am, and introduce yourself. Please state your name.
Beverly Norman.
Ms. Norman, you had a question?
Yes, I was just wondering, was Mark Ritchie and the Attorney General supposed to be here today?
Their presence was requested by the committee.
Well, I was just wondering why the union people sitting right directly behind me knew about a half an hour before the meeting started that they weren't coming.
They
were discussing it.
Right. They were. We were informed that they would be sending representatives instead of appearing on their own behalf.
It just reminds me of the people in Wisconsin that didn't want to vote on something, so they took off for another state.
Thank you, ma'am.
Thank you.
Thank you. With that, committee members, thank you for your time. This committee is adjourned.